So welcome back. Delighted to see you all on a Friday morning for day 2 of our, I feel very confident in saying, fabulous conference, and excited to get us going with our first panel this morning. Before I forget, I want to remind everyone again, including those of us who are watching this on YouTube, there is visit slido.com #law75. If you would like to ask questions, even though you're not in the room, it's pretty simple and in fact even kind of fun. I tried it on a previous conference, so please feel free to do that. But beyond that, without much further ado, I would like to introduce our speakers today. That is Professor Hamish Stewart, who will speak about Justice Bob Sharp, as we would think of him here. Jean-Christophe Bédard-Rubin, who will speak about Justice Catherine Swinton, and Angela Fernandez, Professor Angela Fernandez, who will speak about Denise Rhéaume. So Hamish, I will let you start it off. You can go to the podium, whatever you prefer.
Good morning, everyone. I'm going to begin with a brief genealogy. Caesar Wright hired Marty Friedland. Marty Friedland hired Robert Sharp. Robert Sharp hired Mayo Moran. And in a fit of absent-mindedness, Robert Sharp also hired me. I think a year before Mayo, I believe it was. And so it was a great honor for me to be asked to speak about Bob Sharp's scholarship. We were asked to focus on one particular work or one particular book of the figure that we were discussing, and in Bob Sharp's case, there was really quite a lot to choose from. I would say that his scholarly work falls into 3 different categories. I looked only at his scholarly work for this purpose. I didn't actually look at any of his judgments as a judge of the Court of Appeal. That, I think, would be worth another paper at least, but I looked only at the scholarly work. And I would say it falls into 3 categories. First of all, there are 4 books which I would characterize as works of doctrinal scholarship. There's Habeas Corpus from 1976. There's a book called Interprovincial Products Liability Litigation, which is perhaps one of his lesser-known works. There's a book called Injunctions and Specific Performance, which is still available in a loose-leaf format, and a co-authored book on the Charter of Rights and Freedoms. The first edition of that book was co-authored with Catherine Swinton, who we're going to hear about later, and is now co-authored with Kent Roach. So that's the first group. And the second group are works of legal history. And I'm not going to go through all of them. There are several of them. Perhaps the most significant is his biography of Brian Dixon, which was co-authored with Kent Roach. And the third category has so far only 1 book in it, but I'm hoping for more. And that's his book, Good Judgment, which is a series of reflections on law, the nature of judging, and so on. So there was a lot to choose from. I decided to talk about his first book, The Law of Habeas Corpus, which was published in 1976, which is the published version of his DPhil thesis at Oxford. Now, this is unquestionably a work of doctrinal legal scholarship. I take it that the purpose of doctrinal legal scholarship is to accurately state the law of a particular jurisdiction at a particular point in time. This type of scholarship has 2 characteristics that one might call positivistic. And I know the word positivism is sometimes used in a negative sense in this law school, and I'm not using it in that sense in this particular sentence. I might in another sentence, but not in this one. It has at least 2 positivistic characteristics. At least in the first instance, it takes law as a fact, as something posited, something to be understood and described. And second, it has no difficulty at all in conceptualizing the idea that there might be a difference between what the law is and what the law should be in light of some other perspective. Now, I had initially prepared a whole section of my talk contrasting doctrinal legal scholarship with legal theory, talking about different kinds of legal theory, defending the value of doctrinal legal scholarship, and arguing for the interdependence of doctrinal legal scholarship and legal theory. But yesterday, Peter Benson did that. He did that extremely effectively in his discussion of Stephen Wadham's work. So I'm not going to do that, except to say that I agreed with the way Peter thought about the relationship between these two different kinds of legal scholarship. I do want to say this, though, as maybe a slight amendment or a slightly different way of thinking about what Peter said. If it's the ambition of doctrinal legal scholarship to state the law as it is, one has to ask, well, what is the law as it is? Because every body of law has within it themes and counter-themes for any proposition of law, no matter how uncontroversial it seems. You can probably find someone somewhere, a judge or a learned authority or a statute, which says something different. And I've certainly found this in my work on Section 7 of the Charter. So, of course, that doesn't mean you shouldn't generalize. That doesn't mean you shouldn't try to say this is a proposition of law supported by this body of legal materials. If you couldn't do that, you wouldn't even be engaging in this enterprise. There would be no point. What it does mean, though, is that the core demand of doctrinal legal scholarship to state the law cannot be answered without making choices about exercising judgment, as Sharp might say in his later book, about what to set aside, what to take into account, what to treat as the central and what to treat as the marginal, what to treat as the main propositions, what to treat as the counter propositions. And you can't do that, of course, without some set of values that bear on those questions. So I want to illustrate this with reference to the book on habeas corpus, Bob Sharp's book on habeas corpus. In another work, he tells us, and I quote, that habeas corpus is the common law remedy allowing anyone illegally imprisoned to petition the court for immediate release. The writ of habeas corpus commands the jailer immediately to bring the prisoner before the court to explain the reasons for the imprisonment. If the judge finds the imprisonment to be unlawful, the prisoner is entitled to immediate release. Habeas corpus is a cornerstone of the rule of law and a fundamental common law constitutional guarantee of the liberty of the subject. So that's what it is. In the book, Bob Sharp provides us first with an overview of the writ, and then goes through a whole series of doctrinal legal questions about the writ. What kind of review does this writ involve? What kind of fact-finding is appropriate when a writ is applied for, and what kind of evidence can you lead in support of the fact-finding that you want to take place on an application for a writ of habeas corpus? What happens to the writ in times of actual or alleged or imagined emergencies? Does it still function? How does it function in those times? How does the writ interact with criminal law? Can it be used as a kind of an appeal mechanism where there is no right of appeal, as historically there was not a right of appeal in most criminal matters, or even if there is a right of appeal where the prisoner's rights of appeal have run out? Difficult and interesting question. Interestingly, in Canada now, the position seems to be that a person who has been imprisoned for an offense can rely on the writ of habeas corpus even if his or her appeal rights have run out. And there's very recently in the Court of Appeal, there's a decision called Forster and the Correctional Services of Canada, which illustrates that point, a decision written by our former colleague, Lorne Sawson. What is the temporal and geographical scope of the writ, rather? I learned on page 185 of Sharp's book that the writ of habeas corpus runs to the Isle of Man, but the writ of habeas corpus does not run to Scotland. I would not have guessed that in advance without having read the book. So all of this material is presented as one might expect in with the utmost clarity and precision, as one would anticipate. It is also, as one might expect, a little bit dry. Now, I hope I'm going to, this may seem rude for me to say this, but I feel emboldened to say it because when I told Bob that I'd chosen this book to write about for this symposium, he said, well, isn't it a little dry? And I had to admit, well, yes, it is, but it's nevertheless a very interesting book. Somewhat dry. So I was looking for moments in the book as I was reading it that were not dry. And I found one. In fact, I was quite startled when on page 97, note 5, I found the word intolerable. The word intolerable used to describe a series of cases. Where does this word intolerable come from in a book that is supposed to be stating the law as it is in a precise, clear, relatively dry format? Where does that word come from? Well, where it comes from, of course, is from the normative orientation of the book, because I don't think you can do any kind of scholarship, and certainly not doctrinal legal scholarship, without some normative orientation. And although Bob Sharp doesn't quite put it this way himself, I think the book is really about the role of the writ, and therefore the role of courts and the role of judges in a system of law that is oriented towards human freedom. One of the most basic freedoms is the freedom to move about, the freedom not to be detained, and the writ of habeas corpus is an important element of the protection of that right. So you won't be surprised to learn that the word intolerable in this page 97, footnote 5, is used to refer to a series of cases where courts refuse to even consider applications for habeas corpus in times of war and in times of emergency because of the wording of a statute that appeared to empower the executive to imprison people and at the same time to exclude the possibility of review of that imprisonment under habeas corpus. Specifically, he's concerned in this footnote with a line of Canadian cases interpreting Section 5 of the former War Measures Act. That section provided that no person held under the Act or regulations enacted under the Act shall be released upon bail or otherwise discharged or tried without the consent of the Minister of Justice. The cases in this footnote, generally speaking, held that this section meant that a person held under the War Measures Act could not succeed on a habeas corpus application no matter what the merits of it were. In a case called Baranek, a First World War decision, the Ontario court said, the applicant was interned on the basis that he was an enemy alien, on the basis that he was Austrian, and he said, well, actually, I'm not, because I was naturalized as a British subject some years ago before the outbreak of the First World War, a fact which, if true, would mean that his imprisonment under this statute would not be authorized by the regulations that were enacted pursuant to it. So he applied for habeas corpus and his application was refused. And what's remarkable, or as Bob would say, intolerable about the decision, is that the court wouldn't even consider the merits of his claim. They wouldn't even investigate the factual basis of whether he was correct in asserting that he was actually a British subject and therefore not subject to imprisonment under these regulations. The court said, in a sentence that really took me aback, of course, this decision does not affect his rights at all. The court said, if he be a British subject, he ought not to be detained as an enemy alien, whatever other charge might be brought against him. But all that is for the consideration of the Minister of Justice first. Bob says, the reasoning used to evade the effect of privative clauses should be used to avoid these kind of results. If the power has been exceeded, strictly speaking, the prisoner would not be a person held under the Act, and the section would have no application. Which is right, but you can't get to that conclusion without considering the merits of the application, which is the very thing the court refused to do on the basis that the wording of the statute prevented it from doing so. Now, Kent Roach said yesterday that in relation to Marty Friedland, that Marty does not have a fully worked out theory of justice, but he does have a sense of injustice. And I think one could say the same about the way the word intolerable is deployed in this footnote in habeas corpus. It comes up once again later in the book. The word intolerable appears once again later. And I found it without using Control F. So there. I won't go into the second use of the word intolerable, but as you can imagine, it revolves around similar issues. You don't have to have a fully worked out theory of justice to see that there is something at least troubling about us reading a statute so that it prevents independent determination of the merits of a person's detention, especially when another reading of the statute is readily available, another reading of the statute supported by administrative law principles and by the fact that the law, generally speaking, should be oriented towards human freedom. I would add that the possibility of making progress on issues of justice without having a fully fledged theory of justice is itself a philosophical position about justice. And in fact, it's one that's worked out in great detail in Amartya Sen's 2009 book, The Idea of Justice. So this is meant to illustrate the inevitable interaction between doctrinal legal scholarship, which I did describe, and legal theory, which I didn't describe, but I think we all have a sense of what it is, especially after yesterday's discussion. And I'll just conclude with a quotation from Bob Sharp's forthcoming memoirs. In one chapter of the book, he describes his time at Oxford and the writing of this book and its reception. And towards the end of the chapter, he says the following: "My thesis was accepted for publication and appeared in print in 1976. Not long afterwards, Professor J.A. Griffiths, who I think was then at the LSE, published his important and controversial book, The Politics of the Judiciary, in which he quoted a lengthy passage from my thesis and book, criticizing wartime internment decisions for ignoring legal considerations and deciding cases on the basis of politics. So maybe there was more legal theory in my book than I thought." So thank you.
That was a perfect ending. Thank you, Hamish. A perfect ending in perfectly dry fashion. Very nicely done. So we'll go to Professor Bédard-Rubin.
Okay, so good morning, everyone. I'm glad to see that even if Arthur didn't get the memo yesterday about the turtlenecks from Ed and Peter, that at least Hamish and I have gotten the memo from Cecil Wright about the jacket and the tie. So my presentation will be slightly different from the ones we've heard yesterday and the one we just heard from Hamish. It was quite moving, actually, yesterday to hear stories about how Professor Weinrib became Ernie, or Professor Sharp became Bob, because Professor Swinton never was my professor, or my colleague, for that matter. So she never became Kathy. And even if I have done some bad things in my life, none of them was bad enough to force me to appear in front of her as Madam Justice Swinton of the Ontario Superior Court, a capacity in which she officiated from 1995 onwards, after a relatively short, perhaps compared to other people we've been talking about, but illustrious career of 15 years at this faculty, teaching constitutional law and labor law. So the work that I will talk about more specifically is Swinton's book, The Supreme Court and Canadian Federalism, The Laskin-Dixon Years, published in 1990. A fateful year in Canadian constitutional history, not only because it is the year when the Meech Lake Accord ultimately failed to bring Quebec back into the constitutional fold, but also because it is the year I was born. So it's fascinating to see how a book written almost 35 years ago captured so well the theoretical stakes, and for that reason remains an unmatched pedagogical resource to introduce students to the disputes that occurred during this formative period of Canadian federalism of the 1970s and 80s. And I think there are more excerpts from this book than any other work of scholarship in the Canadian Constitutional Law Casebook, which professors across the country used to introduce students to the mysteries of Canadian federalism, from the color of margarine to the ineffable nature of emergency power. So I will proceed in 3 steps. First, I will say a few words about federalism in North America in the middle third of 20th century, the background against which Swinton is writing. Second, I will explain how her approach to federalism was distinctive and how it participated in a wave of renewed interest in federalism in the 1990s. And third, I will offer some concluding thoughts about the ways in which I think her approach can inform our federal imagination today to grapple or tackle issues that Canadian scholars need to turn their attention to. So for many scholars in the 1970s and 80s, it seemed that the long arc of federalism in the middle third of the 20th century pointed towards uselessness. Opening this period in the 1930s, progressives were bemoaning the structures that federalism imposed on central states, and former defenders or proponents of federalism, such as Harold Lasky, were even writing about the obsolescence of federalism towards the end of the decade. And indeed, in the United States, after World War II and up until the 1990s, it seemed that the Supreme Court was unwilling to impose the constraints of federalism on the power of Congress to pass legislation. There were no statutes struck down on the basis of the Commerce Clause in the US from the late 1930s until the mid-1990s, and only one on the basis of the 10th Amendment, and the Supreme Court overruled its decision 10 years later. So in Canada, of course, the story was slightly different. Because after all, it seemed that by the time the charter was adopted, Canada had gone through many rounds of negotiation and had been living to the rhythm of periodic federal provincial conferences for decades. And the Supreme Court continued to enforce the federal division of powers, but it was more lenient, perhaps, in its application, particularly more lenient regarding the limits on federal power. But this flexibility could be seen mostly not in the decisions of the court, but in the rise of what's been called executive federalism. The constraints imposed by federal law seemed rarely determinative of the final allocation of powers and responsibility. So we saw the rise of intergovernmental agreement, for example, or public contracts. And scholars writing in the 70s and 80s, such as Paul Weiler or Patrick Monahan, increasingly saw the law of federalism as being relatively useless. Executive federalism, in other words, allowed the constant reallocation of jurisdiction and responsibility in an ongoing basis. And while there were some limits, there were almost always ways to bargain one's way around the decisions of the Supreme Court of Canada, whether through interdelegation of executive power or intergovernmental agreement. So it seemed that lawyers didn't have much to say about federalism, actually. Law was irrelevant. It was the domain of political scientists talking about the power relations between political actors, be they elected representatives, governments, bureaucracies. Which brings me to Swinton's distinctive contribution. And I cannot do justice to a rich analysis, but I'll underscore 2 central elements, central points that she makes in her book. The first is that law matters. In federalism, the law matters, and it matters not just to governments, but to individuals as well, to people who actually live federal lives, one might say. In fact, many of the changes that we now associate with the advent of the Charter, what Alan Cairns called the Citizens' Constitution, can in fact be traced back to changes in federalism doctrines of the 1970s and early 80s. Relaxed rules on public interest standing, the admissibility of social science evidence, more interveners, more flexible remedies, all arose in cases dealing with federal law issues. And as she says, quote, "These cases convey the belief that the Constitution belongs to the citizens of Canada, not to the politicians who control federal and provincial governments from time to time." So while courts do make policy choices, they do so while ensuring access to courts for affected parties, and to ensuring that they do have access to the information that they need to make informed political decision, constrained, of course, by the rule of law and past decisions. Which brings me to the second important contribution of her book. Because by underscoring the inherently political nature of those federalism disputes and decisions, Swinton was moving the debate about the nature of constitutional adjudication in a more theoretically sophisticated or philosophical terrain. Most of the critics of the court thus far had fallen for the positivist view of judging, which is that, roughly, when law runs out, judges just make some stuff up. And her approach was richer, based on a Dworkinian conception of legal interpretation. She was presenting constitutional issues in a way that, at bottom, they were moral and theoretical issues. And there was no sharp divide between the positive law of federalism and those deeper moral and theoretical issues. So it's fascinating how she illustrates the theoretical depth of those federalism disputes by providing intellectual histories of key figures, key judges, both their personal trajectory before they sat on the court, but also through their decision at the Supreme Court. Brian Dixon, Bourlaskin, and Jean Betts. And even though we have now excellent biographies of Brian Dixon and Bourlaskin, her work on Jean Betts, I think, is still unmatched. So, of course, Swinton was not alone. The Meech Lake Accord and the rounds of constitutional negotiation that occurred around the time she was writing the book led many scholars to revisit the history of Canadian federalism, in particular political theorists and historians. They were really, to bore the theme of today's conference, looking forward by looking back. Dick Risk and Robert Vipon wrote and taught about the Canadian constitutional tradition here and published articles on the topic. Samuel Lasselva's The Moral Foundations of Canadian Federalism, or Paul Rumney, Getting It Wrong, How Canadians Forgot Their Past and Imperiled Confederation, were all of the same genre. But Swinton's contribution, which arrived early in that wave of scholarship, was distinct in this group in that instead of seeing the relevance of federalism in the initial allocation of power made by politicians, or the reallocation of power in the rounds of mega-constitutional negotiations with Quebec or Indigenous peoples, for example, she underscored that citizens, lawyers, judges participate on an ongoing basis to this federal project. And the role of the constitutional scholar that her work exemplifies is perhaps less to influence those allocative choices than to fertilize the federal imagination, right, with those theoretical and moral dimensions, and thus help make explicit the possibilities that the law of federalism affords. Okay. Let me offer just a few concluding remarks, why I think this work is relevant for today. There are two elements, I think, or two areas that arose in the intervening 35 years that became increasingly pressing and that constitutional scholars need to turn their attention to in perhaps a Swinton-esque fashion. One is, of course, the reconciliation of Indigenous legal orders and the Canadian federal system. So while many scholars are talking nowadays about treaty federalism, it seemed that treaty is perhaps a too restrictive a way to understand the relation between Indigenous people and the Canadian state. We see a plethora of new kinds of instruments, contracts, agreements that are treaty-like but not treaties, perhaps legally speaking, that all participate in the reorganization and perhaps the redistribution of sovereignty in the Canadian system. So they need some deep rethinking about the nature of sovereignty, and perhaps understanding the theoretical depth there will help us make more sense of what is going on with these instruments that recognize what the court calls Indigenous difference. And the second is perhaps was triggered, I'm tempted to say, by something that happened at the time that Swinton was writing, that is increasing integration between Canada and the United States. So she was writing at the time that NAFTA was negotiated, and adopted. And since then, we've seen a recently deterioration of what we thought was the constitutional future of this country and its southern neighbor. Now, there had been discussions about what it meant, what free trade meant for the future of Canadian sovereignty, or what increasing collaboration from the perspective of national defense meant for Canadian sovereignty. But it seemed that recently, since the last few months, scholars are pressed even harder to think what it means to be a sovereign country, considering that some of the attributes of sovereignty, as Jean Baudin called them in the 17th century, seem not so easy to grasp in our North American context. So, of course, Swinton does not offer a recipe, but she offers, I think, a model of federalism scholarship, where scholars address not only the positive law of the federal division of powers, but theoretically engage with the theoretical issues raised by the nature of federalism and the federal nature of public power that inevitably inform those positive law decisions. Thank you.
Thank you so much, Jean-Christophe. Also really being for your agility in moving forward and backward and really doing justice to the conference theme of looking forward by looking back. And we'll go to Professor Angela Fernandez.
Okay, thank you so much. It's so great to be here speaking at this conference. I have some books with me, which I know the students in the room who are here, Ricardo and Maxi and Daniel, you guys know I never come without books to pass around. It's just one of my things. But yeah, no turtleneck, no tie. But I am doing my best to help bring in spring with the dress this morning. Okay, so my paper is called Denise Rhéaume and the Women's Court of Canada, Feminist Judgment Projects and Rewriting Pearson and Post, which, for those of you who don't know, is the famous Fox case or infamous Fox case in property that gets used to introduce students to the concept of property, one person chasing the fox, the other person intervening and takes the fox. And it's always kind of central to things that I'm thinking about. And so I'm kind of weaving that into the talk and also the paper. I want to say two things by way of preliminary remarks. One is just to acknowledge that this part of Rhéaume's work is a very narrow slice of her work. Okay, so there's so much there, and language rights, theoretical work, and so on and so forth. So I'm really not trying to, encompass the whole corpus of the work. It's really narrowly looking at this Women's Court of Canada and her own rewrite that she produced as part of this project. So, but because, it has had such a large impact internationally, the Women's Court of Canada, it's really important to talk about it. And so then that leads to my second preliminary remark, which is to express gratitude to Rebecca Cook, who was the person who, when we were discussing this project and the conference at the faculty retreat last May, it was Rebecca who said, we really need to include Denise and what she did with the Women's Court of Canada, given its very successful spread from, being born right here at the University of Toronto Faculty of Law. Okay, so the paper then does three things, which I'm going to lay out for you here. First of all, to explain a bit about the background and the history of the Women's Court of Canada and feminist judgment projects, which get abbreviated to FJPs now. There's so many, so they're just called FJPs. And to also explain about Rhéaume's own rewrite of the 1999 decision law, which was about Section 15 discrimination on the basis of age. And then secondly, the looking forward by looking back part is to talk about sharing my own experience doing a rewrite of Pearson and Post for a US FJP feminist judgment project on rewritten property decisions. So that's one of the books I brought up to pass around. You see, it's got a library slip. Oh, here it actually is here. And anyway, so if you want to flip to, you can see it. And I see a contingency from the library in the back, and I just want to acknowledge you guys and just be like, we couldn't do any of our work without you. So it's very, very good to see you here. Okay, and so then the third part of the talk and the paper is the conclusion, where I tie Réaume's work on the Women's Court of Canada to Karen Knopp's work on the Tokyo Women's Tribunal, which is a work that I know many people in the room are familiar with. This was another kind of reimagined court, blending fact and fiction, what Karen called faction. Okay, and so that's the plan. So first to the Women's Court of Canada and the FJPs. So this idea was born around a dinner table at a downtown Toronto restaurant on a conference about Section 15 of the Charter back in 2004. Okay, and I think about 2004, and I'm like, that's the year I came to the faculty. It's over 20 years ago now. It's a long time ago. Okay, and what was happening was lawyers, activists, and academics were lamenting what they were understanding to be an overly narrow approach to Section 15 that was being taken by the Supreme Court of Canada. And someone blurted out, well, why don't we show them then how to do it? Let's rewrite the decisions that we think they got wrong. Okay, and then what happened was the Canadian Journal of Women in the Law published 6 of these rewrites. Okay, and as I mentioned, Réaume's was about the case Law, which was a Section 15 case in which the claimant, Nancy Law, had alleged discrimination on the basis of age because she was 30 years old when her 50-year-old husband passed away, and the Canada Pension Plan at that time did not provide survivors' benefits to anyone under the age of 45 unless they had dependents or they were had a disability. Okay, and it's an interesting case, and Réaume actually does reflect on this in the introduction to it. It's not a case that's ripe for rewrite in the sense that a grave injustice was done, probably by denying the benefits that were denied to Law. But Réaume was really interested in picking it up and looking at it nonetheless because of the fact that the court hadn't talked about the sex gender discrimination. It wasn't argued, and so that was kind of the reason that the case didn't talk about it. But there was some feeling, I think, by the people who were involved in it that, well, probably an amicus curiae brief could have been brought, in which case they could have covered this aspect of things. But Justice Iacobucci, in the actual decision, said that the scheme did not violate it did not discriminate a discrete and insular minority. Those under 45 is not a discrete and insular minority. It didn't violate Law's human dignity or disadvantage her in the long term, stereotype, exclude, or devalue adults under 45. So, as I mentioned, sex gender discrimination was not argued, and there was a feeling that it should or would be good to have that addressed. Okay, and LEAF, the Women's Legal Education Action Fund, many members of LEAF were part of the WCC, the Women's Court of Canada, and so in a way, I think of the rewrite as being more or less, what LEAF might have said about the issue had they been given the permission and the ability to intervene. And so what Réaume talks about is things like women in heterosexual relationships are much more likely than men are to find themselves widowed. Typically, women will have a lower earning power, so it's going to have more of a disadvantageous impact on them. And even able-bodied women without children could be thrown into financial chaos or poverty by the death of their usually older male spouse. And so Réaume used the decision as a occasion to talk about those issues. It's really, I think, an exercise in thinking through the problem in gendered terms that the court and the case itself hadn't provided, specifically dignity, which is a very theoretical concept, very difficult to understand, but here to really look at it in a practical, grounded way, which Réaume spoke about and said she always thought was really good for teaching purposes to do that. And she did use the rewrites in a course called Rewriting Equality in 2008, 2009. She also talked about how she viewed the pedagogical value of the approach to be modeling critical legal thinking and really seeing the fork in the road crucial to disrupting the impression that we sometimes get that a case result is inevitable. So in a way, it's almost like a dissent, but you don't have to abide by the confines of the actual being in the actual judge. And so you can sort of, take a more capacious approach to what you're going to talk about and what you're going to argue. So this could have been a discrete and confined domestic national experiment focused on one topic, Section 15 equality, in one area of the law, constitutional law. But instead, just the opposite happened. And in fact, this approach really exploded as the model spread first to England and Wales, where a publication was published in 2010, Australia in 2015. The first US collection was from the US Supreme Court judgments in 2016, New Zealand, Scotland, and in the US, Cambridge University Press has a series that has published many of these rewrites. So the one that's going around is the property one. It's one of the more recent ones, but they've done one in tax law, reproductive justice, family law, trust and estates, employment and discrimination, tort, property, health law, criminal law, corporate law, immigration law. It's like there's a children's one, there's an international law one. It's really, I think exploded is the right word. There are feminist judgment projects in countries as diverse as Brazil, India, Central and Eastern Europe, Africa, Pakistan. There's an excellent website that's hosted by the University of New South Wales, where all of the projects are listed and you can check them out. So it would be an understatement then to say that it's been very successful and it's ongoing. So by the time I came to this, doing a rewrite, and it was suggested to me by someone who approached me after a book talk when I was talking about my own book, Pearson and Post, which I don't know if I brought it, I may as well pass it around. The rules about doing rewritten judgments by this time had become really rigid, So in the U.S. especially, this is it's a cottage industry, really. So, these things are really being pumped out. And so, there's these rules, like you can't cite anything later than your own case, you can't put footnotes or any explanation, and so on. And so, anyway, my original issue was that I wanted to rewrite the decision from the perspective of the fox. So this is what this was my starting position, and they were very quickly like, no, you can't do that. So I was like, okay, so what'll I do instead? I could say, well, what could the fox say, or what would the fox say? So I kind of ended up like toggling like that, and I don't know, it worked okay. It was a bit clumsy, but it's okay. But really, my other big problem was that like I'd read a 300+ page book about this case, so I was like, oh my God, how am I gonna just shrink that back down into just a rewrite? And so but I decided to think of it that way, almost like, okay, like condense it, write down. Most people are not going to read a big long book like that, so maybe the rewrite could be almost in a way a bit of a replacement for the book. And so I could comment on things, new stuff that I discovered about the case, look at the land, the beach is not being wasteland, settler colonial occupation of the land, the animal, and so on. These issues that had come to seem to me to be very important in the process of writing the book for many years. I found contemporary feminist sources from 1805, which was not easy. We changed the fox from a him to a her. I confronted the impossibility of having a female racialized judge sitting on the New York Supreme Court in 1805. Like, this is just, by a certain point in this process, I was like, this is the elephant in the room. Like, how am I going to deal with this? And so I thought, well, I better just talk about it directly. The other issue was just that, the violence around this case. I mean, the violence in killing the animal, but it's embedded in this case that has so much humor in it and so much. So that's always been a little bit of an issue in terms of trying to figure out how to not be a person who is going to come across as like someone who can't take a joke, but at the same time, to imitate in a way the mock solemnity that's there in the decision, and really in a way mirror the elaborate, what I call legal solemn foolery in the book that's there in the original decision. And that was kind of how I decided to handle it. Now, there are time travel challenges when you're writing about an older case that's not there. Like if you're writing about Section 15, a handful of years after the decision. You don't have to change the way you talk or the way, your concepts are not going to be anachronistic and those sorts of things. But once you go back to older cases, you have these issues. So that time travel point leads me to the conclusion, just to say, in relationship to Karen Knopp, that Karen really put her finger on this problem when she was talking about the Tokyo Women's Tribunal. So that tribunal was sitting in the year 2000 as if it were post-World War II, as if it were 1946. So they constituted themselves that way. And they used the term sexual slavery rather than, for instance, talking about the forced prostitution to describe the wrongs that were done to comfort women who were organized to do sex work for members of the Japanese army. And Karen very helpfully drew on a review of this book, A.S. Byatt's novel Possession, which I won't pass around because I don't have time, but that she really used that to discuss this combined fictional and factual aspects of reimagined court exercises. And so, playing forward the Women's Court of Canada and the feminist rewrite projects, I'm thinking about a rewrite project involving animal law cases, probably property ones that involves escaped animals. Also a project on legal education that David Sandomirsky and I are doing on student rewritten canonical contract cases, where we're mashing together rewrites with legal archaeological materials on the decisions. And these examples are not necessarily explicitly feminist, but certainly the animal law one, at least, will deal very centrally with dignity and the dignity of the particular non-human animal that we're talking about, which, especially in the older cases, would never have been contemplated. But we're going to try to show how it could have been. It maybe not could have been in its time, but could be now, given that those cases are really still now in a way because we teach them as if they're now for precedent purposes. So anyway, lots of complicated aspects going on with these things, but it's very nice to have the opportunity to share it a little bit about it with you if you haven't already heard about it.
Wonderful. Thanks so much, Angela. And again, weaving many different strands together, and also lots of looking forward by looking back throughout everything that you offer to us. So, floor is open. First of all, I guess also inviting anybody on, I guess I'm not sure that this is a panel, in our row of comfortable chairs to engage with one another, but please, anybody who would like in, I'll give the microphone. Hang on, I have to get back into the swing of things here, which means getting a little bit of exercise and going to Mariana.
Thank you all for these wonderful presentations. I have 2 points. The first one, I think, is to Angela and putting her in dialogue with Hamish. I think both of you talked about this, a topic that came up yesterday, which is this: how do we do doctrinal analysis while also doing theoretical analysis, right? And I think that theme is coming back. So Angela, I wonder whether this rewriting exercise is the quintessential example of trying to do exactly that, right? Like, instead of writing a treatise about feminism, you just deploy the entire framework in order to show how this should have influenced a concrete judicial decision. So that's my first point. The second point is in the spirit of sharing anecdotes, which we had done a lot yesterday. I just want to share an anecdote about Denise, about her language rights work. So when I was in my third year review for tenure, Denise was in the committee, and she came to me to say, I think we should recognize everything you write in Portuguese. And I said, no, you can't. Nobody here reads Portuguese. How are you going to evaluate that or assess that? And she said, well, we can't hire you and ignore the fact that you're writing in Portuguese, and we can't ignore the fact that anything you publish in Brazil is probably reaching a much larger audience than anything we publish here in Canada, right? You're talking about 200 million people, 1,000 law schools. God knows how many people are reading your work down there. And that, I remember that conversation bringing me back to the idea of what is it that we're doing when we are internationalizing our faculties and universities, which is the work I'm doing right now, right? And it's interesting because as an international student at Yale, I always assume I'm there to take, not to bring anything. I'm there to learn their language, to learn their law, to learn their scholarship. And now the work that I'm doing here at U of T is exactly the opposite. It's to say, no, we're bringing all these international scholars and students because they bring value, and we need to acknowledge what they're bringing to the table. So the language is a point in which I think it becomes very concrete, and I want to connect this with the discussion about treaty federalism, right? Because I think this is what do we mean by we're integrating different systems and different cultures and different languages? Thank you.
All right, please, who would like to pick up on any of the different threads that Mariana wove?
Well, I just was going to pick up on the international part, Mariana, because, you and I were graduate students, international graduate students at Yale at the same time. And that experience of like, you're here to learn their, ways and then maybe bring them home, and that sort of thing is very much. But I feel like when you were the Dean of Graduate Studies here, I really feel like you brought that sensitivity to that role in terms of feeling like, well, no, for us, with our graduate students, we're going to sort of, view it differently and have them feel that it's also different. So anyway, I'm really glad that you raised that. But in terms of the rewrites, I think in a way it's just exactly what you said. It's sort of a show not tell kind of a thing. So it's certainly, doctrine is very important. That's why you're kind of there. But also maybe there's something that's very theoretically interesting. So for Denise, I really think it was the dignity concept. But you're not going to sort of write a didactic kind of treatise type thing about dignity. You're going to instead try to look at it in this very particular fact situation, which, is really a way of bridging our teaching and our scholarship, because that's what we're doing with teaching all the time. But sometimes we're just kind of doing it on the side and not necessarily like integrating it in. So that's what I think is really cool about what Denise was doing. She was really trying to kind of think of everything as a whole and really sort of embody it. And, one of the things, and Rebecca pointed me to this source when Hilary Charlesworth was talking about the rewritten projects, she talked about prefiguration, like this idea that you paint a world, and certainly this is true for animals, you paint a world where it's not the world as it is, but it's the world as you hope it will become, and that, it can't really ever become that unless people imagine it to be that way first. So this idea, be the change that you want to see, which, Karen used to always say, is very kind of literal with this type of an exercise. And so I think, that's part of what makes it very cool, is it has that integrative function.
Jean-Christophe, did you want to respond?
That's a very good point, the language part. I mean, I remember at the retreat, I think I also suggested Denise for the language, the legacy is there's lots of material to cover there. And so we could talked about different aspects of her work. So I'll say a few words on this, but also a few words on Catherine Swinton as well about language and federalism. One thing that's fascinating about the book is she does take the Quebec perspective seriously. She does read material in French, and she does kind of present this for an English-speaking audience, for example, what Jean Bette's perspective is, contextualizing the intellectual milieu in which he was evolving and how it shapes his approach. So in a sense, it's a model. We know this in Canada, right? Francophone scholars talk to themselves, and Anglophone scholars are there in their own kind of linguistic bubbles. But the fact that she's doing that work, which is hard, it's hard to do, is I think part of the reason also why this book has stood the test of time so far. And it's not, as I say, it's not just true for English scholar. French Canadian scholars tend to read French Canadian scholarship on federalism and don't pay attention as much as just the way in which those questions are approached in English Canada, which tends to be different. So that's true. How I would connect it, perhaps the language question, with these deeper questions about sovereignty, where we need to think more deeply, is I think that indeed there are issues raised by multilingualism for just the possibility of a law-based order. Law as perhaps not completely something that is language-based, but at least for
a large part language-based. What does it mean for what multilingualism means for a law-based order, a social order, is something that I think public law scholars need to think more deeply about. And it's something that Europeans, constitutional scholars, do talk about. As they're building the European Union, the fact that they have 26 or 27 languages, and that their, for example, opinions of the European Court of Justice need to be translated in those languages. What does it mean for law to be expressed, and one might say, in a meta language like that? I don't know if we have answer, but it's certainly something that we need to think more deeply about, especially if we're talking about indigenous legal orders, and not 2 languages, but potentially 58 or 59. So, yeah.
Hamish, anything? No, not on this one. We'll go to Mayo.
Thank you. That was wonderful. I was reflecting on the fact that yesterday we noted that the women that we were talking about didn't appear till this morning. So thank you all for the wonderful discussions. I was wondering, and I guess, you can weigh in on Bob on this one if you like, but both Kathy and Denise, as we knew them, were carving a path for what it meant to be a woman and do legal scholarship. They kind of chose in some ways quite different paths. I think Denise confronted the issues of feminism and gender more directly, but you can certainly feel them in Kathy's work as well. And I just wondered for both of you, I know you were talking about particular elements of it, but in your review of the scholarship, there's sort of blazing trail in many ways for what it means to be a woman in doing legal scholarship. And I wondered if you had reflections on that. And, Hamish, you may have reflections on it too. I don't want to leave you out, but it's just interesting that they were early, early figures for all of us who followed. And I wondered what you thought, how you saw that in their scholarship.
Oh, you have to think, okay. I'm like, I actually also wanted to think about it. But no, I think, it's interesting. Part of, for Denise, it was very, very explicit. And so I don't know that she would have been interested in the rewriting project, but for the feminism. So I feel like for me, in a way, like I'm inheriting the privilege of being able to come to this and, maybe do the feminist approach, but maybe not if the case doesn't really seem to call for it or bring it up, and that really is like, just being able to come from having scholars before you who are senior to you trail the path in that respect. And Mayo, you yourself, so important in that respect, right? And Rebecca and Carrie and, and so I think, but I think it is difficult. And I think it's hard to maybe talk about it explicitly, and so there is a little bit of okay, you can kind of feel maybe this is a bit uncomfortable or this is a little bit hard, and sometimes you really do feel like you're kind of damned if you do, damned if you don't, like so many things with gender, right? Like, are you going to bring attention to it, are you not, and so on and so forth. So I think for Denise, I think probably she had probably a very clear understanding of how to sort of approach it and really do it very, very head on. And, that worked for her and that suited her. And I think that's really good. But the anecdote that Mariana shared about, the language and so on, I think that really does show that was the way she just was about things, that she was going to just kind of call it out and then we're going to figure, well, what do we do next? And so, yeah, those are just some thoughts that spring to mind. Yeah.
It's something that I thought about yesterday, actually, where they were explaining why I'm ashamed to admit I didn't really realize it was structured chronologically, the panels, but of course it makes a lot of sense. Yeah. I would say 2 things. So I think there's the part of the work, or what she's trying to do there, is also to take the Constitution back from men in meeting rooms negotiating and deciding everything about the Constitution. So that's, I think, part of this broader movement where there's something about popular engagement with the Constitution. I'm thinking about perhaps scholarship that came later, but Reva Siegel's work on the de facto ERA in the US. It's an example of that where there's more popular engagement. I think it shows throughout her work on federalism. That's true, even if it's not kind of explicitly feminist in this vein. So perhaps also we could see this in another dimension of her work, which is more the labor law part. And it's interesting that for that generation, many constitutional scholars were also labor lawyers, kind of continuing the tradition of Bora Laskin, Paul Weiler, and at that time, Patrick Macklem, I think, was teaching both constitutional law, labor law. David Beatty, she was as well a labor arbitrator. So maybe this is where those questions came up more kind of obviously, or more present. But again, there was probably some an elective affinity between thinking about public power in a federal way, that is thinking about power, not just power exercised by governments, but in other locales, in the workplace, et cetera, and what that means to engage critically with the exercise of public power in these decentralized institutions, or kind of in a more pluralistic vein.
All right, we'll go to you next.
Thank you. My name's Stephen Bowman. I'm a graduate of this faculty from the late 70s. It might be the first time I ever put up my hand in a lecture hall, finally today. Only took me a little late. My question, never too late. I quite agree with that philosophy. And I've spent over 40 years in private practice. But my question is a looking forward, looking back question. So many of the things that have been said have talked about the emergence of voices that were not previously heard. The labor, women, indigenous people, and so on. And so many threads in these things. And the intolerable war crimes cases, War Measures Act cases dealt with the dominance of political thought at that period versus political power versus court power. The emergence of these different voices is a thread that runs through all this. And we're now at the threshold of animals having a legal voice. Everyone's talking about artificial intelligence rising to the level where it starts to have legal rights and a legal voice. So, and we heard Mariana talking about whether her writing in Portuguese would be considered, and the very insightful thought that if obviously it should be, but it seemed to be a new thought at the moment it was expressed. One voice that we don't hear so much in Canada, we talk about Canada as a mosaic, but when it comes to law, we're very much an assimilationist society where immigrants are absorbed into our legal thought. Is there are we entering a stage where perhaps new Canadians who come from other societies and other parts of the world will start to have a voice in some of these kinds of discussions about law? Because as I say, we've always thought initially there were French, there were English, and then there were more English, and it was all English and French. And then it's expanded into these other, to listen to and be influenced by these other perspectives. Are we at a point where we're going to start to hear from the immigrant/new Canadian perspective in some way? And that's a sort of an open question for the panel.
Thanks very much. Please, who wants to start?
Well, I mean, I would say, you can look very specifically and look at Indigenous law in law schools in Canada and the priority Post-Truth and Reconciliation Commission on saying, it isn't just French and English. We got to acknowledge this is also part of the tradition and not just like a part, but a part that got squashed out, and to do that. But in terms of diversity generally, like I've been teaching a lot less long than many other people in the room, but, in the last 20 years, I would say that the student population has become really diverse, and that's very noticeable. And it also, I think you can see how it changes the way the discussions go. Like we have these cases where have old Lord Denning decisions that have quite embedded sexism that I think when I first started teaching them 20 years ago, people wouldn't really notice. Maybe I would raise it, maybe not. It wouldn't really resonate, you know, or like these racisms in cases and things like that. But now, like, these things are just, everybody sees everything immediately all the time. And that's very refreshing, because it means that the you know, the cases can now speak to us in new ways. And so I think that's very important. And that's not on the issue of like people coming in, can they practice, and what are the barriers to practice and so on, which I really don't know that much about. But just in terms of sort of what I see from where I sit, I think that is really quite a lot of diversity now. Yeah, I mean, yeah. Yeah, I mean, hopefully it would, I would think, but I don't know. No, Hamish? No, that's good. Okay. We hope for more.
You're all good? All right. So let me, before I go to Rebecca, who wanted to ask a question, I am actually using Slido, believe it or not. So Brenda Cosman, who was here yesterday, but unfortunately has a cold and is watching online today. I'm just going to read out, it's more like an observation than a question. She says, "I'm sorry I'm not there today, but I wanted to speak a bit about Denise, who took me under her wing when I was a law student. I took a course on feminist analysis of law in 1984, maybe the second time she taught it. And then she says, I can honestly say that it changed the trajectory of my career. I had been a feminist in a generic sense, but the course showed me that it could really be brought to bear on law in ways that were important and urgent. Yesterday, I heard about so many, Stephen, Ernie, Michael, changing the course of our colleagues' lives and careers. Denise changed mine." So that's from Brenda, and with that, I'll go to Rebecca.
Thank you all, and I just want to comment on Denise and maybe pick up on a few themes on looking forward. Sorry. Denise's rewrite in the first edition of the Canadian Journal of Women in the Law focused specifically, as Angela explained, on equality. And those rewrites have withstood the test of time. Like any judgment, those that are superior withstand the test of time. I use those in working on rewrites in international human rights law with regard to women. I kept going back to them and back to them. So I just want to stress how important the quality of that first edition, and I'm sure it's because of her influence, has been reflected in subsequent editions of the Canadian rewrites. Angela mentioned the book her on rewriting her property one, and here's a theme in terms of looking forward. How we think about bringing international and comparative law together, and this is a theme that Jean-Christophe and I have started a conversation on, but I very much want to continue. And that's one of the things that these rewriting projects have done. They have allowed for different feminist groups in different countries to talk across national boundaries very, very significantly, whether you're talking property rights. Those rewriting property judgments in one country have looked at property rights in other judgments, tax law, et cetera, not to mention Denise's first edition of the Canadian Journal of Women in the Law on equality rights. So I think we have a lot to learn from these rewrites on how we go forward in thinking about bringing together international and comparative law. So questions on your thoughts, Jean-Christophe and Angela. I'll just say one other thing about the law school. Angela's rewrite of Pearson, it really is a very significant rewrite. And I wonder, we had through our intensive course, Jose Alvarez here this January, and he's written a very important book on women's property rights under CEDAW. And if he hadn't read your book, he's certainly very influenced by it. in the quality of that book. And I'm just wondering whether you actually ever talked to him about his book and how he framed it.
Yes, okay. Rebecca, I haven't. So maybe you could introduce me to him, and I will get on that. But you know, one thing that what you're talking about makes me think I really should have raised and emphasized is like a part of the thing with the Women's Court of Canada is people they started to kind of be like, oh, what's our impact, and are people citing our judgments like as if they're judgments or in scholarly work and things like that. So 10 years out, they did a citation search trying to see and it turns out that courts were not really citing the judgments very much, and they kind of seemed to be taking that like that was negative, But what they did find was that it was being cited by scholars of law and literature, people in other fields. And so, this whole idea that you write them in a plausible way so that they'll actually be cited like a judgment, or maybe even someone might mistakenly think it's a judgment or something like that. I feel like maybe that was a goal that was kind of, I don't know, but it's definitely shifted and changed now. And so I think what that does is it brings to the forum a kind of freedom where you don't have to think, oh, I got to make this actually look like a judgment that, could stand in the place. It's just a different kind of exercise. And I think part of the exercise is very much the process and bringing the people together, as you say, from different jurisdictions with different backgrounds, kind of making a space to talk about things that you care about and you share the values, and maybe it's a bit of a minority view and so on. And certainly with the animal rewrites, that's definitely what we're going to be doing. And I think we maybe are probably going to take a more kind of creative, almost like a creative go more in for Karen, the fiction and the fact, go more in the fiction direction. But, I do feel like what's very cool about the forum is that it is really very free. It's very free to do these different things depending on what you think you want to accomplish and where you want it to go. And so that future aspect to it is really, I think, this is very lovely.
Does that work? No. Oh, no. There it is.
When you
okay,
talk, it should
fantastic.
be on.
Okay, yeah. So that's a great question. Of course, well, okay. I'll preface by saying this. I think that there was in this the wave of scholarship that I was trying to talk about in the 1990s. That's perhaps a deeper theoretical engagement with the issues of federalism opened the door, I think, to more international or comparative work, partly because no constitutional tradition is elaborated in isolation. But I'm not sure that it's been carried all the way to its full potential. So though there was some of that work, and here I'm thinking not only of Catherine Swinton, but Dick Risk and Robert Vipin's work on kind of more intellectual history that Jim was talking about, that they were doing in the 1990s, early 2000. I think the next wave would be to bring more of that kind of intellectual history that other people elsewhere in the university are doing, that is much more transnational, much more comparative, and that constitutional scholars could benefit from if they took cues from it by looking at a kind of a deeper well of legal ideas that move across border, sometimes easily, sometimes are more significant constraints, but just thinking about how easily legal ideas move across borders or across continents is very worthwhile. Unfortunately, I can't say it's something that a lot of people are doing, but I hope more people were doing it.
So I have a question. I have a question for Hamish, but I'm gonna introduce the question with a long two-part anecdote about Denise, actually. So the first paper I ever published actually was written under the supervision of Denise in a project that she engaged in at the law school at the same time that the start of the Women's Court project happened. It was called the Section 15 project. So it was the 20th anniversary of Section 15's coming into force when I was in my last year of law school. So I wrote a paper about Section 15 in that project, so I got an A or whatever the grades were then, and then I said to Denise, "Oh, maybe I want to publish this paper," and Denise says, "Yeah, no, I think that's a good idea, but now I'm going to tell you what I really think about it." So she did, and I edited it and I published. So it was great. But at the same time that I was doing that project, I was doing another project, another directed research project, actually under Ed's supervision, sort of co-supervised by Bruce, about kind of private law theory. And so I said yesterday that I had Michael and Ernie in my first year of law school. And so to be clear, this is entirely my fault. But up until my third year of law school, I sort of understood it to be the case that the universe of legal philosophy was exhausted by the question of whether or not corrective justice or law and economics was the right way to think about private law. I was like, that's sort of all there is. So as I'm doing this project, I'm doing the Section 15 thing, and at the same time I'm doing this private law thing. And so this is the first time that I start to get exposed to general jurisprudence as a subject matter. And I remember very clearly sitting in Denise's office in the course of this, and I say something like this to Denise. I'm like, Denise, there's like all this other legal philosophy out there in the world. And Denise, right, so not everybody knows, but had a DPhil from Oxford and has a very close relationship with Joseph Raz. Denise levels this like unbelievably sardonic stare at me, and she just goes, Chris, I know. So, but the story is revealing of the same point that Angela, that you brought up yesterday about the jurisprudence syllabus, the jurisprudence course in rights context, right? So Hamish, the questions for you, the questions about the relationship, that you think of yourself, or what you think Bob thinks about what doctrinal scholarship is and how it relates. So I know that you said that Peter talked about this a little bit yesterday, but in some sense, like I think the project of the habeas corpus book is such a good illustration of that point that I made yesterday, Wright's idea of the slot machine, right? So like what would doctrinal scholarship be? Is the idea that I'm just going to have a list of every case that's ever been decided that involves the writ of habeas corpus and just sort of name them and say, and this case decided this, and this case, right? So that's obviously not it. And I think Bob's book is a neat illustration of that. So I wonder if you might just say a little bit more about what you think, or what you think Bob thinks about kind of the relationship between doing that sort of traditional doctrinal scholarship and legal theorizing more broadly, and I think that that the story about the footnote that you told it's a neat story, because it sort of suggests that like there's in some sense the theorizing is inescapable, but on the other hand, or at the same time, the theorizing is around here seems to be kind of distinctively tied to the law, and there's like there's a lot of stuff to say about that. So I wonder if you just might, yeah.
I think you kind of just said what I wanted to say. But I would like to add a couple of things. First of all, you could, I suppose, do doctrinal scholarship on the slot machine model. And if you did that, then that footnote of Bob Sharp's book would have said, here are some cases where courts refused to grant the writ. And that would be what it was. And that wouldn't be interesting. It wouldn't be helpful. I mean, I said it was dry book, and I said that with Bob's implicit blessing. But if it was purely slot machine, it would be dry. And Bob's book is dry, but it's not boring. If it was a slot machine, it would be dry, and it would be boring, and it would be useless. So yes, I think you need to have some kind of orientation, normative orientation, even if you don't know you have one. I think most people are working in this level are self-aware enough to know that they have one, but even if you don't, you have to have one. I want to say something else, though, if I may, and this relates to the question that someone asked, I forget who it was, about the experiences of Kathy Swinton and Denise Riom as female faculty members early, when there weren't that many at that time. And this is a looking back thing. I don't want to rekindle old debates about the Bridge Weeks and whether they were a good idea and whether we did the right thing. Please don't. I've just been instructed not to rekindle old debates. I would, however, say that when I was a first-year student, I did not have any female faculty professors at all. And so for me, the Law and Feminism Bridge Week was actually the most important one, because not only because that was when I was first introduced to female faculty members, but also because of the way they talked about the law, which was different from what I was hearing in other classes. And for me, that was a very important moment in the first year. So I just wanted to say that.
Well, since you're saying that, this is an anecdote that is not related to U of T at all, but I've shared this with a number of people. When it was coming to Canada as a graduate student that somebody first asked me whether I had ever contemplated an academic career, and my first thought was they're making fun of me. And in hindsight, I've often wondered why that was my reaction. And then it was precisely because the system that I went through, you are one student in a sea of 600 maybe. The professors all have white hair, but they were all men, not a single woman. And it simply not occurred to me that an ordinary person, female, could be an academic. So there is something quite powerful and important. And we still have quite a long way to go, but certainly the way that the program actually dramatizes this in a way, I think, does make an important point. So I think we have a great point to end here. I am really grateful to the three of you for wonderful presentations and bringing these colleagues back to us, and we can chat more in the break, and we'll be back here at 11:45 for the next panel. Thank you.
Hi everyone, I'm thrilled to be here. So I will just get right to it. We're just here to introduce the speakers for our final panel. So we've got Professor Martha Schaefer speaking about Carol Rogerson, and excuse me, Professor Anna Sue speaking about Rebecca, and Richard Stacy will be speaking about Lorraine. So without further ado.
Okay, well, thank you, Vincent, and thank you, conference organizers, for inviting me. I'm actually really happy to be here today to be able to speak about Carol Rogerson. Carol was first my teacher, then she became my colleague and my mentor, and to this day, she is my good friend. So in honoring Carol, I'd like to say a little bit about Carol as a person, and then I'd like to talk about Carol as a scholar, focusing on what I think is her most significant accomplishment, which is the creation of the Spousal Support Advisory Guidelines. So Carol was on the faculty here for almost 40 years, and as anyone who was lucky enough to have taken a course with her well know, Carol was an excellent teacher whose classes were always clear, meticulously organized, and engaging. I was actually fortunate enough to have taken 2 classes with Carol, family law and then a seminar on family law and policy the following year. And it was largely because of those 2 courses with Carol that when I joined the faculty, I decided to teach family law. I taught family law here for about 10 years before I made the shift into evidence. When I taught family law, Carol was the most generous mentor. She was always encouraging, always supportive, and always willing to share her wealth of knowledge. And Carol's warmth and generosity continue to this day. And I will add here that I taught criminal law when I started on the faculty as well, and I still do. And my mentor for criminal law was Alan Mewett. He was a wonderful person, and of course, we talked about him yesterday. So as a law professor, Carol taught and wrote in 2 areas, constitutional law and family law. But family law was Carol's real passion, and Carol became one of Canada's top family law scholars, and along with Professor Rowley Thompson from the Dalhousie Law School, the co-author with Carol of the Spousal Support Advisory Guidelines, Carol became the top scholar in Canadian law on spousal support. From the start of her academic career, Carol wrote about the economic consequences of marriage breakdown, with a particular emphasis on the effects of marriage breakdown on women and children. So she was very focused on these gender dimensions. Carol's scholarship included articles on child support and domestic contracts, all of which are extremely good in their own right. But Carol's work on spousal support was particularly noteworthy. In a series of articles written in the 1990s and the early 2000s, Carol wrote about the evolution of spousal support law and the place of the spousal support obligation in a modern no-fault divorce regime. Those articles still are frequently cited by the courts across the country. They were cited by the Supreme Court of Canada, which relied heavily on her work, Carol's work, in the major decisions on spousal support it wrote in the 1990s. But in addition to this scholarship, this academic scholarship, which I'm going to refer to as her traditional legal scholarship, Carol made an enormous contribution to the practice of family law in the real world. And in fact, it is not an exaggeration to say that Carol transformed the law of spousal support in this country by creating, along with Professor Rowley Thompson, the Spousal Support Advisory Guidelines, which unfortunately go by the acronym, the SAGs for short. Okay? So it isn't often that one can say that a colleague transformed an area of law, but that description is entirely accurate for Carol. So what exactly are these spousal support advisory guidelines? Well, the Spousal Support Advisory Guidelines, for those of you who haven't worked in family law or taken family law of late, the Spousal Support Advisory Guidelines are informal, non-binding advisory guidelines that calculate the quantum and duration of spousal support that should be paid upon relationship breakdown. Although these guidelines were commissioned by the Federal Department of Justice, the guidelines are advisory only. They are not legislated, and therefore they do not have the force of law. They are simply, as Carol put it, a tool for lawyers, mediators, and judges, and in fact for separating spouses themselves, a tool that can be used to generate a range for the appropriate amount of spousal support that should be paid when a relationship breaks down. Now, for those who do not work in family law, these guidelines may not sound all that significant. But the importance of the SAGs to Canadian family law is impossible to overstate. And to explain that, I need to say just a tiny bit about the history of divorce law in this country and the state of spousal support law before the guidelines were enacted. So before 1968, as many of you may know, Canada did not have a National Divorce Act. Divorce was available, but it varied by province, and the grounds for divorce were very limited. In all of the provinces, divorce was fault-based, meaning that a divorce could only be granted when one of the spouses had committed what was known as a matrimonial offense. And in most provinces, the matrimonial offense set out in the legislation was adultery. In point of fact, to return to the theme of scholarship on gender, there actually was a gender-based double standard here in terms of the law of divorce, and that was that a husband could get a divorce based on his wife's adultery alone, but a husband's adultery alone was not a sufficient basis to grant a wife a divorce. A wife needed to show that her husband had committed not only adultery, but as well another matrimonial offense. And here's where spousal support comes in. Spousal support, or alimony as it was known at the time, was a gender-specific remedy. It was only payable by husbands to wives, and it was also tied to notions of matrimonial fault, right? It was only payable by husbands who had been guilty of a matrimonial offense to their innocent wives, right? Wives who had not committed any kind of matrimonial misconduct. That was the state of the law until 1968, when Parliament passed this first National Divorce Act. That act made two important changes in terms of divorce and spousal support. First, it loosened the link between fault and divorce because although it retained fault-based grounds for divorce, the 1968 Divorce Act also permitted, for the first time in Canada, divorce to be granted on a no-fault basis, right, on the basis of living separate and apart for 3 years. But second, this Divorce Act changed the basis of spousal support. It made spousal support a gender-neutral remedy, right? Spousal support could now be claimed by husbands from wives, although obviously that did not happen very often in the 1960s or even the 1970s. And the Divorce Act of 1968 also broke that firm link between fault and spousal support. In 1985, Parliament passed a new Divorce Act, which took these changes even further. That act made marriage breakdown the sole ground for divorce, and it expressly stated that marital fault could not be considered in determining the amount of spousal support payable at the end of a relationship. All of this divorce law reform was taking place alongside significant social changes, right? During this period, traditional gender roles were beginning to break down, although one could certainly say that we have still a lot more to do on that score. So traditional gender roles were beginning to break down, and women were entering the paid labor force in larger numbers. And these legal and social changes posed a fundamental problem for the law of spousal support. If spousal support was no longer a gender-based and a fault-based remedy, what was the basis for awarding spousal support? Or to put this question slightly differently, what was the justification for ordering spousal support in a no-fault age? Now, the 1968 Divorce Act did not offer any answers because it was completely silent on the objectives of spousal support. But the 1985 Divorce Act did address spousal support objectives, and it expressly set out 4 objectives that spousal support orders should seek to achieve. And I'm going to paraphrase these very quickly because it's never fun going through legislation. There was a compensation objective, which was set out actually in 2 provisions. Spousal support orders were to recognize any economic advantages or disadvantages to the spouses arising from the marriage or its breakdown. Spousal support was also to apportion any financial consequences caused by undertaking childcare responsibilities during and after the marriage. Spousal support was to relieve economic hardship arising from the breakdown of the marriage. And finally, spousal support was to promote the economic self-sufficiency of each spouse within a reasonable period of time, insofar as that objective was practicable. Now, the inclusion of these objectives in the 1985 Divorce Act was clearly helpful, but setting out these objectives also gave rise to a problem. And the problem was that these objectives were not fully consistent with one another. They sometimes pulled in very different directions, and the Divorce Act gave no guidance as to which of these objectives had priority over the others. And here's where we get to the state of spousal support law before the creation of the guidelines. The courts, and in particular the Supreme Court of Canada, stepped in to try to fill what Parliament had left out. They tried to articulate an overarching theory of spousal support to justify the modern spousal support obligation. Without getting into any details here, the courts were not successful with this endeavor. So by the end of the 1990s, spousal support was, to use a technical term, a hot mess. Okay? Because it lacked guiding principles, spousal support law had become highly discretionary, with the result that it lacked certainty and predictability. Similar fact situations yielded very different results in terms of the amount of spousal support ordered. And because the law was this uncertain, lawyers couldn't predict outcomes. They couldn't provide effective advice to their clients. And this, of course, made it hard for people to negotiate or mediate spousal support settlements. By 2001, the Department of Justice took notice of this highly unsatisfactory situation, and it decided to investigate the possibility of creating guidelines to assist in the calculation of spousal support. And not surprisingly, they turned to Canada's 2 most prominent scholars of spousal support, Carol Rogerson and Rolly Thompson, to spearhead this guidelines project. It was clear from the outset of this project that designing spousal support guidelines was not going to be an easy task. To be successful, spousal support guidelines would have to be able to apply to the diverse ways in which spousal relationships are structured and to the many different points during a spousal relationship when a relationship can break down. And to put this in slightly more concrete terms, to be successful, guidelines would have to be flexible enough to apply to long-term traditional marriages, right, where one spouse had probably, maybe, never worked in the paid labor force, to medium-length marriages where there are still dependent children at the point of relationship breakdown, to short-term marriages where there are no dependent children, and to all sorts of relationships in between. Whether it was even possible to create guidelines capable of responding to these situations was an open question. And in fact, a number of earlier Canadian studies had concluded that it could not be done. Nonetheless, less than 4 years later, in 2005, Carol and Rolly produced draft advisory guidelines, And those guidelines, with some minor tweaks, became the Spousal Support Advisory Guidelines, final version, that was released in 2008. Okay, so very briefly here. How did Carol and Rowley succeed in creating these guidelines when the prevailing view was that it could not be done? The answer is that they adopted a collaborative approach that merged academic scholarship with the on-the-ground practical experience of people who work in the family law system. So Carol and Rowley brought the big picture analysis to the project. Carol's academic writings on the theories of spousal support gave the project its conceptual underpinnings. And both Carol and Rowley supplemented these conceptual underpinnings by undertaking a comprehensive analysis of the reported case law on spousal support. But because the vast majority of family law cases settle, and the outcomes reached in those settled cases are not necessarily reflected in reported judgments, Carol and Rowley brought on board an advisory group of 13 experienced family lawyers, judges, and mediators from across the country. The advisory group brought to the project their on-the-ground experience and their intuitions based on that experience as to how typical spousal support claims should be resolved. Okay? So I'm really going to cut to the chase here to say simply this. Working with all of this information, Carol and Rowley isolated patterns or clusters within the reported cases, itself a monumental task. They identified best practices within those clusters. They tested those best practices against the advisory group's intuition, and then they created mathematical formulas that would produce outcomes consistent with those best practices. Those formulas became the Spousal Support Advisory Guidelines. Not going to say much about the details of the guidelines. I'm just going to end here by talking about the impact that those guidelines have brought. So the guidelines have been enormously successful, and they have, as I said at the outset, transformed the state of spousal support law. Even though the guidelines are advisory only, they were rapidly adopted by lawyers and judges throughout the common law provinces in Canada. And with the exception of Nova Scotia, they have been endorsed by all of the appellate courts across the country and all the provinces, including the Quebec Court of Appeal, even though that hasn't seemed to have filtered down to Quebec trial courts or, in fact, Quebec lawyers. Okay? As of last fall, by Rowley Thompson's count, the guidelines have been used in 425 appeal decisions and over 5,200 trial judgments. As a result of the ubiquitous use of the guidelines, they have succeeded in creating certainty and predictability among judicial decisions on spousal support, and that has also made it far easier for lawyers, mediators to assist their clients in negotiating out-of-court settlements. So I'm going to end there, but I just want to say that Carol's work here was well recognized as it deserved. In 2015, Carol was awarded the Carolyn Toohey Impact on Public Policy Award by the University of Toronto, and the citation for that award said that Carol had played a pivotal role in shaping family law. No other legal academic in Canada has had such a great impact. And in 2019, Carol was awarded the Law Society Medal, given to lawyers who have made outstanding contributions to the profession. Thanks.
Okay, good morning, everyone. Like everyone else, I'm really happy to participate in this event, not only because it's a celebration of what this law school has become, but it's also an opportunity for me to publicly honor the work of Rebecca Cook, who's one of the biggest figures in international human rights law advocacy and scholarship, particularly in the area of women's rights, but certainly not just. I should also note that she's the founder of the IHRP, the International Human Rights Program here, still the only clinic of its kind here in Canada, and this has really made such a profound impact on the lives and career of the students, of the countless students who have had the opportunity to be a part of it. In the introduction of her latest volume, Frontiers of Gender Equality, Transnational Legal Perspectives, which was published in 2023, I should know, by the way, that I just recently learned that this was awarded a prize by the American Society of International Law, the prize given by the Women in International Law Working Group. So congratulations, Rebecca. Yeah. In her introduction, Rebecca inserts a little bit of biography on how she came to travel this path of addressing gender injustice. She wrote, "My journey started early in life with exposure to domestic violence, the realization that women did not have equal educational opportunities with men, and the understanding that individuals could not live proudly according to their own sexual orientation. These early exposures propelled me to travel further to better understand their causes, and in law school I took a course on women's legal history, which was when I began to fathom some of the origins of these injustices and their continuities and similarities that condition many women's modern-day experiences." End quote. Well, one can definitely say, and the rest is history, if you want to look at how her scholarly and professional career had turned out. I did not have the opportunity to be one of Rebecca's students here in this law school. I'm a new Canadian, as somebody mentioned earlier. So I just came here a few years, it's crazy, it's 10 years ago now. But I know people who have been, they're professors now, they have only so many good things to say about her. And in any event, anybody who's a traveler in the human rights law space, as I am, will be familiar with her work on women's rights and reproductive rights. I had initially decided to just focus on her recent publication, but I thought it would be useful to just take a look at some of her major works and see if there's a theme that I could discern. In 1993, she published an article entitled Women's International Human Rights Law, The Way Forward, and this led to her important 1994 book entitled Human Rights of Women, National and International Perspectives. In 2010, she came up with another book entitled Gender Stereotyping, Transnational Legal Perspectives. All of these, of course, are on top of a tremendous body of work in terms of volume, articles, friend of the court briefs that she has co-authored or wrote herself and submitted to a variety of human rights tribunals all over the world, you name it. And all of these encompasses a variety of issues that are united in their aim of advancing women's welfare around the world. Now, I noted two things from these very quick survey. First, the collaborative nature of her work. All the three books that I mentioned, for example, are edited collections with a good number of contributors coming from different parts of the world. In her 2023 book, Frontiers of Gender Equality, has 25 authors addressing the evergreen topic of gender equality from a number of different disciplines and geographic perspectives, and from scholars and practitioners at different stages of their career. In her 1994 collection, it's 22 authors. Right? So this multi-author structure is important because it shows you how much of a networker and connector Rebecca is, always connecting people with one another and those who might benefit from learning from each other's insights and experience. And this is really about laying down the foundation of international legal and political action as lawyers. But it's also important substantively because I think it's a recognition of the fact that advancing international human rights law, and particularly women's rights as human rights, this should be a conversation that begins from the ground, either as scholars or lawyers that actually litigate these cases. It's about combining theory with practice in order to go forward. And it's also a recognition of the global nature of the work promoting women's rights and gender equality. I'm originally from the Philippines, so I'm very, like many people who come from a similar background, we're very grateful for people like Rebecca who have the resources to be able to be part of this network that can advance the work of women's rights, and not just women's rights, but human rights generally in different places around the world. And so this is how Rebecca's volumes can squarely confront the immense challenges of advancing women's rights in a variety of geographic settings, including and especially in places where tradition, religion, and culture might hinder the implementation of these rights in practice. The second thing that struck me from my brief survey is Rebecca's commitment to international human rights law as a way to secure the goal of advancing women's rights and promoting gender equality. Her edited collections are full of serious engagements with treaty and convention law, the feminist rewriting that we talked about in the earlier panel, feminist rewriting of famous decisions of human rights tribunals. Now, this might be such a weird thing to take note of because it seems pretty obvious that women's rights are human rights, but this was not always the case. In a 1990 paper, Rebecca wrote that international human rights law has not been applied by women solely because of, has not been applied effectively to redress the disadvantages and injustices experienced by women solely because of their gender. ... Moreover, the traditional human rights groups have been unwilling to focus on violations of women's rights, violation of women's rights, and have not fully understood the potential of international human rights law to vindicate women's rights. We also know that, for example, that feminists have been skeptical, at some point in time, to use the human rights framework as a vehicle to advance their cause, because there's a tendency of the rights approach to be susceptible to the public-private distinction, which they hold in part responsible for why gender inequality has persisted today. And so while the frontiers of gender equality will never really be quite settled, and gender equality is still a problem that we're still grappling with in many settings today, we already have come a long way from that observation made in 1990. We know that women's rights are human rights, and gender equality law is now firmly entrenched within the international human rights legal framework. Now, my brief essay following the urging of Rebecca to travel onto new frontiers of gender equality focuses on gender equality in the realm of artificial intelligence. The goal is not only to explore the issue of gender equality in the algorithmic age, but also to see if Rebecca's faith in our faith in international human rights law as the principal vehicle to realize our moral aspirations is not misplaced. I must admit that our current political moment is testing our faith in the international human rights system, but we have an obligation to obviously keep hoping. And the spoiler, which I won't go into detail here, but in the paper, the spoiler is that the international human rights system remains to be a good vehicle to vindicate these rights, but obviously it will take a lot of work on our part. Now, as some of you might be familiar, and for those who might not be familiar, we're very much in the midst of the so-called algorithmic age, or that we live in an algorithmic society. And this, given the significant impact on the full spectrum of human interests and needs, for example, education, health, the way that we communicate with one another, even the maintenance of a democratic society, it makes sense to put human rights front and center in discussions around AI systems. And that means when we think about its human rights, impact, we couch the risks in the language of human rights. We think of the tools that the human rights system makes available to us in order to take action, either in terms of regulation or to provide remedies in the event of breaches. And so a goal of my essay was to synthesize everything that's out there in terms of what's the state of gender equality in the AI context, and evaluate whether framing it in human rights terms could still get us to the goal of where we want it to be. So yes, of course, AI has a gender discrimination problem and a gender stereotype problem, among other things. And one of the, when we think about gender equality and AI, we usually often focus just on the discrimination part of it. But part of what I write about in the paper is that you have to look at it in a holistic way, meaning that when you look at the very beginning, for example, are women even using technology as much as men? And the answer is no. You already have what the literature calls a gender data gap. And that means if women are not using technology as much as men, women are not adequately represented in the data that the AI system will later be trained on. And that means that the AI system ends up doing, whatever the AI system ends up doing, will reflect this lack of representation, right? So much of these criticized AI systems are often also engineered from a male perspective. So that's what happens, that's what produces all these discriminatory results that you hear about in the news. So for example, when you use any of these popular image generation tools, women are often portrayed in caregiver and domestic roles, while men are often portrayed in professional or business-related occupations, right? Rebecca's work, among others, have shown that these gender stereotypes are harmful because they are also likely to lead to violence. And in fact, that is one of the things that AI has made it quite easy to do, which is to engage in online violence, either in the form of online stalking, harassment, and cyberbullying, right? A lot of these technology are used to basically there's a disproportionate impact on women in the use of these technologies. And so given all of these problems brought about by AI, and because we spend increasingly a lot of our time using these systems, couching these challenges in human rights terms makes sense because that's what's available to us. And thanks to the scholarship of Rebecca and many like her who have done so much in expanding our understanding of what gender equality and equality means, scholars who work in gender equality in the technology context, they're just importing these insights that have already been developed and generated in context in women's rights, literature generally outside of the technology setting. And we know, for example, that gender discrimination embraces substantive and not just formal equality. But this was not really an inevitable conclusion 30 years ago. So I'm not going to go into details now of what human rights does, but I would just note that gender equality is now a core principle of many international soft law documents that govern the use of digital technologies, such as the recently adopted AI Framework Convention in Europe and the UN Global Digital Compact. In a recent book, philosopher Shannon Valor characterizes AI as a mirror because it reflects our individual and collective appearances, including the ugly realities about how humans interact with one another. And as AI systems increasingly shape and influence various areas of decision-making in our society, the imperative to safeguard human welfare and values remain higher than ever. If we intend to maintain the international human rights system as the predominant legal, moral, and political framework to promote welfare and preserve values in this age, then we need to ensure that it's up to the task by considering multiple ways on how we can catalyze political and legal action at home and abroad. At the beginning of my remarks, I opened with a snippet of Rebecca's reasons for why she decided to go down this path of addressing gender injustice. Many people, particularly those with a legal background, whose advocacy is also about promoting and addressing gender equality somewhere around the world, will probably have their own stories as well. But at some point or another, their stories will have to intersect with hers, since she has played such a huge part in laying down the building blocks of this important area of law in our social and political lives. I know that mine does. Thank you.
Okay, thank you everyone. Vincent and I have decided that he's not going to introduce me, so I'll introduce myself. I'm Richard Stacey. I'm a professor here. I teach public law, so administrative law and constitutional law, and that's the context in which I came across and became familiar with Professor Lorraine Weinrub's work. And what I'm going to talk about today in particular is her work on Section 33, the override clause or the notwithstanding clause of Canada's Constitution. And I'm going to do that in two ways. Firstly, just by talking a little bit about the idea that I'm formulating in a paper, which is obviously the product of this conference. And then I'll also talk a little bit more about the influence of Professor Weinrub's work on my own. So I'll start I'll just tell you that the tentative title of this paper that I'm working on, I've titled it How Section 33 Has Betrayed the Rule of Law. So pretty fun, light-hearted work. So that's just a tenor of the direction that I'm headed in. But what I'd like to do in my remarks today is talk about how Professor Weinrub's work as a public law scholar and indeed as an advocate over her career has has tried to articulate the benefits that Section 33 holds, the potential that Section 33 holds for Canada, but also to speak about the warnings that she posted throughout her career and how I think we're now confronting a moment where those warnings are unfortunately ringing true. So what I'd like to start with is to mention that unlike some of my colleagues who are on this panel and the previous panels, I didn't go here. So Professor Weinreb was never my teacher. I was never in class with her. She never told me what she really thought about my early works and scholarship. But notwithstanding that, Professor Weinreb's work, and she won't know this, or at least you might not have known this until she had a look at the draft that I shared with her, was deeply influential on me as a South African law student in the late 90s and early 2000s. Because in South Africa, our constitution moved us from a legislative state to a constitutional state in 1996. And in that move, our jurisprudence, our scholarship was very much aided by the jurisprudence of Canada's Supreme Court and indeed Canadian scholars like Professor Weinreb. And one of the things that most deeply struck me, or most deeply struck us as a legal community in South Africa, but certainly which left a deep imprint on me, was the emphasis on Canadian values, on the commitment to multiculturalism, the comments in the secession reference about respect for minority peoples, federalism as a mechanism of bringing together a diverse group of people in a singular public law community. All of those things were important to us as South Africans, and indeed Professor Weinreb's work in that regard, in forging a way of being together in a constitutional system that was committed explicitly in our constitutional principles to social justice, equality, and dignity. And so, indeed, the first article that I published in 2003 has references to a raft of this Canadian scholarship, work on multiculturalism, work on fundamental values, and not only myself, but colleagues well, not colleagues, but my teachers in South Africa were deeply influenced by the idea of values, fundamental values as part of a legal tradition and as part of a legal culture that I think helped South Africa to move away from a culture of authority to a culture of justification, to a constitutional system committed to underlying values. And it was very easy for me then to come to Canada as a legal scholar and begin teaching at the University of Toronto. And I'll just give you a brief anecdote. I gave a paper in Texas, I can't remember when, several years ago, and I was talking about the importance of values and things like that. And one of the American interlocutors said to me, "Well, you would say that, you're a Canadian." And I said to him, "Actually, I'm a South African." And then he said, "Well, that's even worse." because of I think South Africa kind of amplified Canada's commitment to values. So when I came to Canada, when I was appointed here at the University of Toronto, Dean Mayor Moran hired me. I spent the summer of 2014, having been informed that I would be teaching Canadian constitutional law, cramming Professor Weinreb's work, mostly on Section 33, which was this unique and strange feature of a constitutional democracy that I didn't understand. And without Professor Weinreb's work, well, I have no data on how well my teaching was received in 2015, but without Professor Weinreb's work, I would have been completely at sea. So with that, let me turn to a little bit of the work that Professor Weinreb has done on Section 33. And there are numerous articles, and not only the articles themselves that Professor Weinreb has written, but you can't read anything else that's been written about Section 33 without seeing citations to Professor Weinreb's work. It is ubiquitous and I would say fundamental to our understanding of Section 33. And what's most notable about Professor Weinreb's work in that regard is she presents a way of best understanding Section 33, not, as she says, as a plague on our vision of the Charter, but rather as a feature that celebrates our unique and distinctively Canadian qualities of rights protection. And it's that element of Professor Weinrib's work that I think we need to focus on and celebrate as we go forward, thinking about how to make use of Section 33 in the current political moment. So Professor Weinrib's work does a number of things. The one thing that it does is recount the history, in some senses, the untold history of Section 33. There's this famous Kitchen Accord, where apparently we heard some discussion this morning about white men sitting in back rooms hammering out political compromises. That seems to have been the genesis of Section 33. Apparently it was scribbled on the back of a serviette, although Quebec wasn't there, so maybe it was the back of a napkin. And I don't know if that's true, but certainly the idea is that it was a political compromise. And Professor Weinrib emphasizes the political nature of that compromise, which will turn out to be important as the clause gets used later on. But she also celebrates two unique aspects of Section 33. The one is that it works as a way of legitimizing the very institution of judicial review. Right? So to the extent that courts make these judgments, they need not hold back in telling the government that they have overstepped, because if the government feels strongly enough about it, they can invoke the override clause, the notwithstanding clause. But the second point, which is the more fundamental point and what I'd like to focus on, is that Section 33 provides this opportunity for deep and meaningful reflection on the values that underlie the rights in the Charter. The rights are just instantiations of these values. And what Section 33 recognizes is that there's no reason that courts should have a monopoly on the interpretation of those rights, nor indeed on the determination about whether a limitation is justified or not. And that's the genesis of this idea of dialogue. Now, most 1L students who have come through this university, and indeed others in the country, will have read Professor Hogg's article about dialogue theory, Professor Hogg and Alison Bushell. And I have no doubt that Professor Weinrib would have assigned that article to the perhaps 3,000 1Ls that she's taught in her time here. But she used the phrase dialogue much earlier than Hogg did. I'm not sure if it was the first use of dialogue to describe this political process, but certainly she was one of the originators of the idea of dialogue. And the idea of dialogue that she suggests is one that emphasizes the substantive conversation between courts, legislatures, and indeed the voting public. When the override is invoked, even though the court in Ford versus Quebec says there's no obligation to justify on normative terms to the court, right? Professor Weinrib made the argument that there is a deep and I was going to say overriding obligation on the government invoking Section 33 to make the case to the people that it's a good thing to do. Notwithstanding the fact that it's inconsistent with the right, there are other good reasons to do this. There has to be, Professor Weinrib says, a political cost to failing to make that argument. And indeed, when Professor Weinrib acted as counsel for the Attorney General of Ontario in Ford versus Quebec in its intervention application, the Supreme Court directly cited Professor Weinrib's comments about the political costs. And that never happens, right? The Supreme Court never refers to the interveners. So for that to have happened, I think is testament to the important intervention, the important contribution that Professor Weinrib was making at the time. And the political compromise that was the genesis, the birth of Section 33, I think speaks to the need that there are political costs, that there should be political costs attached to the failure to make that argument. And if you look at the catalogue of Section 33 invocations since 1982, there have been, by the count of one of our graduates, Caitlin Salvino, 24 invocations, 18 of which have been successful. And the failures, as Professor Weinrib notes in some of her work, are those instances where the invoking government could not make the case, where the public backlash was significant enough that they backed away, or in many cases, the government fell in an election before they could even enact legislation having promised to, invoking the override clause. And the political sires of Section 33 had the idea that it would only ever be used in these non-controversial cases, these absurd situations. John Chrétien said as much in Parliament in 1981, where it would be easy to make that case, where it would be easy to make the substantive, value-based argument that overriding rights is the right thing to do. So the conclusion that Professor Weinreb reaches is that Section 33 is not only consistent with our Constitution as a whole, but is indeed a laudable aspect that allows this deep reflection that is not the sole and exclusive province of the courts of what our values require us to do as a political community. Unfortunately, that's only one way of understanding dialogue. And the uses of Section 33 since about 2018 suggest that that is not the dialogue that is actually taking place. It seems to be the case that governments invoking Section 33 in more recent years have either enacted the legislation in the dark, if you like, through fast-tracked processes that cut off the opportunity for public debate. And when public debate or public outcry is made, the government's response is to say, well, we have a mandate from the voting public, and we are acting in the interests of the people. But there has been no effort whatsoever to explain why the government is acting on behalf of the people. There's just an assertion on the basis of this democratic mandate. So what we have, I think, is an assertion of a purely tyrannical and grotesquely majoritarian conception of democracy, on the basis of which the governments are invoking Section 33. And I'll conclude by pointing out that this, whatever you think about the conception of democracy, that's the conception of democracy that seems to be written into Section 33. There's very little textual hook, right, to say that anything else is required by Section 33. But I'll remind you that in the secession reference, the Supreme Court articulated not just constitutionalism and democracy as fundamental principles of our unwritten Constitution, but also the rule of law. And our colleague at this law school, David Deisenhouse, has insisted that the essence of the rule of law is that everyone, every subject of the legal system is entitled to ask the question, but why is this law for me? And to demand an explanation from the lawgiver. And what we're seeing here is an absolute failure of governments to even attempt to answer the question of why this is law for all of us. And so what I think we're seeing is the sacrifice of the rule of law at the altar of this grotesque conception of democracy. And I'll end by reading the warning that Lorraine Weinreb posted in 1990 in an article that I think is prophetically entitled, Learning to Live with the Override. This is in response to the Supreme Court's decision in Ford versus Quebec. Ford, that's a name that has a lot of connection with Section 33. Our constitutionalism, she says, is a seamless web made up of constitutional text, convention, and judicial pronouncement. The override can be understood as intensifying and strengthening its patterns of respect for democracy, difference, and individual dignity. The Supreme Court's interpretation in Ford of the override's purpose, function, and strictures purports to strengthen our commitment to democracy. However, its reasoning cuts the connection between democracy and the other fundamental values for the sake of which we hold democracy dear. And I am deeply worried about the way in which Section 33 has cut our connection to those values. And I hope that reliance on Professor Weinreb's work will help us to look forward to a brighter future than the one we seem to be facing. Thank you.
Okay, so I'm very pleased to be here speaking about Alan's work. I'm sorry, Alan, I can't say Professor Brunner. You're always Alan to me. Malcolm Thorburn, as Chris mentioned, to write the chapter for this volume. He could not be here today, so I leapt in to fill his place and just say, Alan has been a big part of my experience of the UT since literally the day I set foot in Toronto for the first time, like literally the first day. And he has been an incredible mentor and guide to me. He's been incredibly generous and kind when, as Richard was saying, learning the ins and outs of Canadian law, in my case, criminal law. I mean, I went to Alan so many times, questions about public law. Can this really be, is this really what are they saying what I think they're saying? And Alan would tell me sometimes they were and sometimes they weren't. Just endlessly generous with his time and as a mentor, particularly valuable in areas where we agreed, but especially valuable in areas where we disagreed about things. So I just want to, I guess, start with that. One of the things I think is very distinctive about Alan's approach to criminal law and to punishments, for instance, in this tremendous book, Punishment and Freedom, that really sets him apart from, I think, the kind of legal scholarship that, so much of legal scholarship, I would say especially in the public law area and in criminal law as well, is that it's very common when people are discussing public law to be what you might call crypto-normativists. This is related to Hamish's remarks earlier about Bob Sharp. What I mean by that is having this kind of ideas about what right and wrong is, about what's just, what's fair, all this kind of thing, but being unwilling to articulate that expressly and unwilling to just let's have at it. Let's just defend it on the merits, right? Instead to kind of weasel around things and just make assumptions, or well, I don't know if I agree with those assumptions, let's talk about them. No, I don't want to talk about them. I want to talk about whatever, statutory interpretation or something like that. Which, is has its merits. I'm not saying it doesn't have its merits, but one of the great things about Alan's work is he's no, let's have at it. Let's start at it from first principles, right? And so really getting into the moral architecture of the criminal law, which I just think is profoundly important, and you just really cannot make any progress in this area unless you do that. So for Alan taught us that punishment, for it to be just, it has to be more than power wearing a robe. It has to be coercion that the recipient, the one facing the pointy end of the stick, can recognize in some sense as consistent with their own freedom. This is a powerful moral demand. It's one that's grounded in a sense of rational equality. Alan's work has really, I think, contributed a lot to how we think about unpacking this idea that punishment is, in some sense, self-imposed. So I think this is a profoundly important idea. I'm not going to get into the weeds on this in any further than that, but just to say that this kind of grounding idea that Alan so powerfully and eloquently defends is really an achievement. The other thing I would say, I will say, is that what sets Alan apart, and this is a little bit like the inside baseball part of I guess this is all inside baseball. Alan is a proud Hegelian in a viper's nest of Kantians, right? And so while I think that we have the world's leading Kantian legal thinkers here, I'm not going to try and characterize Kantian legal theory, but for Alan, I think he embraces complexity, embraces moral complexity, and does not have the urge to say there's an overriding moral ideal. There's several moral ideals: formal agency, real autonomy, collective community solidarity. All of them are independently important, and Alan's thinking shows us how we can unify them in a coherent and complex dialectical structure. That is a structure, a way of thinking that's quintessentially Hegelian and unmistakably Bruegner. Okay. Now, as perhaps if you've ever cracked the spine of a book of Hegel's, you will know it's not like particularly easygoing. And so I was just reminded when I was paging through this book earlier today that Allen's Punishment and Freedom starts with a list of approximately 30 defined terms, which is just, it's beautiful. I love that. But I will say, let me say here that lest you think like, oh, Allen has spent his life thinking about Hegelian philosophy, but Allen is also, one of the things that's beautiful about it is that he brings it to bear on the law in a very granular way. So when I showed up here in 2011, we had a ridiculously complicated law of self-defense. It was just incredible puzzle box that I basically think nobody in the country really understood. It was partially overlapping. There were different sections that covered different scenarios. It didn't really, like, it broke my head. And I remember once going to Allen and saying, like, what is going on? And Allen was like, well, yeah, it makes total sense. And he had figured it out, right? And he had. And so it's just a way of saying that Allen's able to unify, I think, thinking about the law at a granular level with thinking about law in this very general first principles approach, which I will just conclude by saying, in my mind, reflects the U of T and the Faculty of Law at its best. At our best, this is a faculty that is profoundly interested in ideas in a way that no other law school I know of is like. So with that, that's all I wanted to say. So with that, let's, we have a little bit of time. I think we have until 12:15. I'm moderating, so if you have any questions, please just. Great.
Thanks very much. This is a wonderful occasion. I was here in spirit and on the internet yesterday, and I thought that the sense of the room that one got, even miles away from the law school, was just so warm and intense and really happy. And it was in these very difficult times for everyone, and I dare to say most acutely for constitutional lawyers. It was really a wonderful experience. It also, in a way, changed my mind about my memories of the law school. And Richard's very generous and very interesting presentation and encapsulation of my work on the override also has pushed me to rethink some things. And I wanted just to share some thoughts. The first thing that I want to mention is that I don't know if this is general, but the curse that I carry from my 15 years as a constitutional advisor, but mostly as a litigator, is that I very often wake up re-arguing the cases that I lost. And prominent among those really uncomfortable experiences, which really do ruin my day, is rehearsing the experience of appearing on behalf of Ontario in the Ford case. I should just mention that interveners were given an hour then. Now you have to beg for 3 minutes. And that I was well known in the court. I was respected in the court, that I always came with something to say rather than just sending greetings from Newfoundland, which was often the low point of the intervention process. So Richard's paper prompted me to rehearse in my mind the Ford argument, the whole Ford case in the Supreme Court in real time, without the nightmarish aspects of it. And one of the things I realized in combination with the experience of listening to the session yesterday was how much the education I got here prepared me for this particular piece of litigation, surprisingly, and that I wasn't relying on the education that I got at Yale, where I always think that I learned about the real dynamic of the courts and rights protection at Yale. But the experience of how the court dealt with the Ford case was not what I expected, but also I didn't expect to have an easy time. But it was really shocking because it really was a paradigm shift in their approach to the charter. Lemire started off by asking me, with quite a rude tone, whether there should be any judicial review of the exercise of the override power. And I had dealings with Lemire before on the court, but actually off the court at conferences and things. He was very anxious to talk to lawyers about what they thought about the charter. So I thought that I had quite a nice professional relation with him, but he was quite brusque. As I realize now in retrospect, the answer came from the wonderful administrative course that I had from Colin McNairn. And I was very calm in the court. I was never nervous. And I could think. A lot of people weren't able to think when they were on their feet. And I just said, any grant of power by a political body requires review. And Lemire, who was no slouch in administrative law, was incensed. And this is what he came back with. He said, do you know how busy we are with all the charter rights challenges? We are overwhelmed. And now you're saying we're going to have to judicial review Section 33? And I gave one of my dramatic litigator's pauses. And I said, absolutely, yes. Okay, so that was the end of that exchange. I mean, it wasn't rude, but I mean, it was bizarre to think that there was any other answer. The next thing I remember, there was no video, and I didn't have a junior with me to take notes of the oral argument. Betts was quite stricken when I made my submission that Quebec had used the override retroactively and that was impermissible. He said, show me. So I didn't know what he meant, and I had my factum open, and I gave him the reference to the legislation, and he said, no, show me. And I didn't know what to do. And luckily, one of the other lawyers in the courtroom, there was, we didn't have Xerox material used in the same way as before when nothing was online, found the book, because the library would bring in all the books of anything that was referred to in the factum, and we all sat around, and then they showed Betts the language to show that it had been used retroactively. No one else had mentioned that. This was novel on my part, which really isn't permissible for an intervener, but anyway. And he read it over and over again, and then he said, well, tell me what you think the significance of this is. And then, of course, I said, you'd have no rights protection if you can use the override both forward and backward. And if the whole idea is political responsibility, then you have to be able to have a debate. And you can't have a debate in Never Never Land where your rights are taken away retroactively. Anyway, he didn't say anything else that I remember. And that I was sustained on that point, but just on the rather flimsy basis that the word shall is used in the text. I can't remember the actual exchanges with Dixon and Wilson, but they loved my arguments, which were much more detailed and normative than Richard had time to outline. And they did, both of them were scrambling very intensely to get every word that I was saying down, which I'd never seen in the court. They never looked up. They were just scrambling so much. But what I was doing was giving my whole structure of the charter, which is something I was working on in academic writing that I was doing on the side. And so I knew they were with me. But not only that, but after the hearing, when I was packing up material, the registrar of the court came and said, Mrs. Weimer, could I have a word with you? And he said, Justice Dixon wanted in particular to tell you that your argument was brilliant. Now, of course, I'm very proud of this. But the thing is, I've asked many, many litigators. No one has ever gotten a message like that of anyone that I ever heard. And so, but I didn't need that in a way. I could see that from the frenetic way that Dixon and Wilson were writing things down, that they understood what I was saying. And I knew it was so normatively founded in the whole history of the drafting of the charter that that would be good. And I couldn't believe that Lemire would have a strong force in saying you couldn't review. And Justice Lafray, who eventually wrote, of course, and really decimated the whole charter structure, in doing so, I can't remember him asking any questions. What do I make from that? Well, I think it's interesting that even at this intensity of charter argument in terms of a very specific feature that's very unusual in rights protecting instruments, that it was my general legal education that was so helpful. And I always knew when I saw successful submissions in the Supreme Court that people had to bring such a breadth of knowledge because you never nearly knew what was coming at you. And I thought that I had sort of achieved on that day as much as I could with the court, thinking the way it was. Sadly, of course, the whole paradigm of the charter means that you have to think that Section 33 is an exception and is read narrowly, and that any of its restrictions on normal legislative power are warranted and normatively sound. But the court wasn't of that view, unfortunately. And we live with the consequences of that to this day. Now, I just want to end with a personal note, because another thing came to me yesterday when people were saying, well, I look back on an interaction with a certain professor and it really changed my life. And I want to say that about Dick Riss, oddly enough. And something that someone mentioned yesterday, the essay course that he did, where everybody just had the opportunity to write a paper. It was the only paper I was able to write in law school. And I chose to write, and I have no idea why, I can't reconstruct it in my mind, an essay on the correspondence between the colonial office in charge of Canadian Aboriginal interests before Confederation and the Indian Commissioner in Canada. An odd thing, even when I think that this is what I chose, but anyway, I can't retrace how I got to that topic. And that meant going to the main library, sort of an archive kind of part of the main library of U of T, and reading through, I think, hundreds and maybe thousands of pages of these letters, and in some sort of photo version. And I wrote a paper, and Dick gave me an A, and there was never any discussion or anything like that. But the significance of that paper in the term of the second year was that it meant I didn't carry out my intention of quitting law school. Because I thought that would mean I wouldn't have the discipline to continue writing the paper, and I was enjoying writing the paper. And then by the time I got to Christmas, I thought, well, believe it or not, I'm halfway through. How bad can the rest of it be? And which had to do with me. It's not a criticism of law school. And I was a very disenchanted classicist who didn't find reading cases as a great literary engagement. And so I stayed on, and then I got a job in the summer, for 2 summers actually, with the beginning of the Indian Claims Commission. And then I was finished, and then I got a good job, and things worked out for me. I feel much better about my law school education today, and so I thank the organizers for having provided me this opportunity to revisit this history. And also, I suppose, I want to make the point that no matter how specialized you become, if you don't have that intense, sometimes very technical and very boring foundation in legal structures, then you're really at sea when something comes up that's a first impression. And of course, almost all the work I had on the charter was first impression. And I realize now that it all didn't start at Yale, and that maybe my time at Yale was so rewarding and successful because of the wonderful foundation that I had here at the law school.
Well, first of all, just apologies to Professor Weinrib for bringing those nightmarish experiences back to life.
Actually, I just want to say a few things about Vincent. Vincent and I come to criminal law from completely different perspectives. One can't imagine more different perspectives. I see criminal law as comprehensible in terms of essentially the justification of punishment. He thinks criminal law is explicable without any reference to punishment, that it's part of an administrative state. So it's such a tribute to Vincent that coming from such a different perspective, he can give such a generous and faithful account of my own work. I often say that Vincent has the knack of presenting unassailable arguments for the most indefensible positions. But today's demonstrated also another knack, that for coming out of his theoretical framework and offering a generous, as I said, and faithful account of a different perspective.
The record will reflect the unassailable part.
Just a small point by way of an analogy to the override clause in the Constitution. The GATT, the General Agreement on Tariffs and Trade, and the World Trade Organization that subsumed the GATT, has very similar override provisions on national security, public morals, environmental exceptions, but particularly the national security exception, which has become very central to many of Trump's derogations from tariff commitments, right? And indeed the Biden administration. And the dispute settlement regime under the World Trade Organization has been very reluctant to second-guess domestic government invocation, particularly of the national security exception. And governments don't have to produce critical intelligence information that might justify the exception. So this handcuffs any external review, right? If the governments don't have to produce the information on which they're invoking this exception. So it might be useful at some point for some scholar, not me, to compare the override provisions in the Charter with the override provisions in international legal regimes such as the GATT.
When I joined the law school in 1987, there was a huge divide between national and international law. The national lawyers shunned the international lawyers and vice versa. And what's been very, very exciting about this conference is the way national law and international law is coming together. With Martha's presentation of Carol's work on soft law, on the Spousal Support Advisory Guidelines, I've been taking notes furiously because of a commission I've been asked to be on to look at general principles in health law internationally that have emerged. So I have a question for Martha in terms of what was the magic that Carol had in developing these guidelines that really have emerged into, it seems like, very hard law. With Anna, I want to thank you, especially as somebody who is a techophobe, for taking this idea of gender equality and looking how it might be mismatched in the area, in the algorithmic area. And my question for you, Anna, is in terms of the methodology that's being used to identify the gender discriminatory stereotypes, gender discriminatory wrongs in the algorithmic area. Certainly my work on stereotyping it's very methodological. What is a stereotype? How do we name it? And how is the law doing that? And without that, we don't have much consciousness of the gender discriminatory dimensions. With the whole work of Richard on dialogue and justification, of course, the international human rights system is about that. And I think that system has a lot to learn from some of the debates domestically. So maybe you could address a little bit about how those are interacting, if at all.
I think this is on. Is this on? Yes? Okay. So by my count, we have about 7 minutes left before lunch. So I will answer very briefly to give everybody else time to answer. And what I would say is that Carol and Rolly were in some sense lucky with the timing, but also lucky because, quite frankly, the Supreme Court of Canada had done such a bad job in terms of setting out the principles of spousal support in its judgments. And so lawyers and lower court judges were just desperate for something that was going to bring some clarity to spousal support law. And I say that in part because other jurisdictions did look to Carol and Rolly's spousal support advisory guidelines as models for what they might be able to do in their jurisdiction. The UK is one, I think New Zealand is another, and they were unable to get even advisory guidelines agreed to in those jurisdictions. So there's a bit of luck here, but I would say, like, you know, there's still problems, there's still unanswered questions, but they do really work well.
Okay, thank you so much for that question, Rebecca. I would say there's not a lot of writing on it at this point, to be honest. Most of the scholars who are writing mostly popular trade books on, you know, gender and AI and, you know, anything in that sector has been mostly just building off what we already know from human rights law. They don't. I'm not so sure if I can discern a methodology that they know that, you know, what's being produced by many of these products are, you know, reflect the stereotypes that we already know from real life. And, you know, these are, I guess, historical biases that we've had already from a long time, that the ones that, you know, the people in the volume of gender stereotyping has already identified in many contexts around the world. And so at least there's no systematic treatment or methodology involved in this area yet. And so part of what I wanted to do with the paper, and I'll send you a draft because I completed it quite late, is that it's really just trying to gather everything that's been written on this topic, and hopefully that will be a starting point for people who can do this in a more systematic way.
Thanks, Anna. I don't have much to say about international law, but I will point out that part of the political calculation that provincial governments have made in invoking Section 33 have relied on international law. So Quebec's decision not to renew the language provisions that were the subject of the Ford case had a lot to do with the fact that the international legal community had condemned Quebec's use of the override. Now, that's a very particular kind of historical moment. It's the early 90s. Quebec is, making this secession drive and needs the support of the international community for the recognition of its claim to sovereignty. So that government, and much more sensitive to the reactions of the international legal community, I don't know that. We're at a moment generally where everyone is questioning the kind of place of international law. I don't think many provincial governments in Canada now, using the override clause, know that international law is a thing. And if they do, I'm really not sure that they care. So that's again, I haven't brought a lot of happiness to this discussion today. But there has been work that international has done in this context, and I hope there is more for it to do.
We have a comment the Slido. So from Brenda, she wants to add a note. She says, "I want to add a personal note about Carol. Like Martha, she was my teacher. In my third year, I took family law. I had never talked in class. Always sat in the back. One of those students." I know what you're talking about, Brenda. But for whatever reason, in family law, I sat in the front, and before I knew what I was doing, my hand was raised. Carol, Professor Rogerson to me at the time, ignited a passion for family law, and I never looked back. I feel like I have kind of stalked her. I became a family law professor. I came back to U of T to be a family law professor, and I eventually moved on to her street. Brenda clarifies that Carol has been an extraordinary mentor and a friend.
And to continue on with the mentorship note with Carol, I wanted to just share that, when I first was coming here as a faculty member, Carol was my mentor, the person who kind of shepherds you through that pre-tenure period and makes sure, you're doing the things that you need to be doing, you don't fall, off track. And I always was just so struck by how incredibly modest she always was, and just about everything, but specifically about this project. So listening to you talk, Martha, and hearing the years, like 2004 to 2008, like those would have been those years where we were regularly going for coffee, having lunch, and and she would kind of like mention, I traveled to do this with the guidelines, but she would never give you the sense of the momentousness of what she was doing. And anyway, that was just something that I feel like should really be mentioned in that respect, just how incredibly modest she was, and just also how kind and generous with her time she was. I also had a question to ask, though, too, which is to say, with those guidelines and like those so I think, I don't know if there's lots of different commercial services, but one of them is DivorceMate, where you type it in and then it pumps out the ranges and all that sort of thing. And do you know if she continued to be involved with those aspects of it, or do you feel like it was the guidelines and then she really bowed out, or did she kind of keep a hand in it at all?
The commercial things are completely separate from the guidelines, from the formulas that were created.
Okay, great. I think we are at time. Please join me in thanking all of our speakers.
Just to say, so we have a round table that's going to start at 12:30. The idea is that we all go out, grab lunch, assuming we all want to come back as well. Please come back, bring your lunch, and then there will be a bit of a conversation among us on the panel, but then the hope is very much that there will be a conversation in the room.